Hi, everyone. Harry here to talk about an extremely foreboding order that the Supreme Court on its own issued last Friday that potentially suggests the possibility of a drastic re-narrowing of the Voting Rights Act. They've already taken the Voting Rights Act and cut off 60% of its vigor and effectiveness. And now they're looking at 39 more percent potentially. It would be really, for voting rights in this country, catastrophic. And this is actually this week, the 60th anniversary of the Voting Rights Act. Not that they acted with that in mind. All right. We need a little bit of background. Voting Rights Act, the important seminal statute of the Civil Rights era, early 60s, to protect voting rights, passed under the Constitution in the sense that both the 14th and 15th Amendment, 14th, the general states are, now can't deny due process, equal protection, etc., and the 15th can't deny the right to vote. Each have a special section that says Congress can pass appropriate legislation to enforce this amendment and mandate. And Congress passes the Voting Rights Act, and it has two really important provisions. The most important was the so-called Section 5. Section 5 identified a panoply of states, mainly from the Old South, that had a history of voting discrimination and different nasty stratagems to dilute the power, especially of African American voters, but minorities in general. And it imposed a pre-clearance requirement, did Section 5, so that when those states wanted to mess around with their voting procedures, we'll just put in a little poll tax. Not that they were doing that, but that it was the history of things like poll taxes and really nasty little tricks to dilute the votes of initially, the new freed former slave population, that gave them this record, put them on a sort of probation, and said, you do anything, you change how many hours people can vote or what write-ins are like, etc. It has to go through pre-clearance in Washington in a special section. That section, by the way, has been pretty much cut to shreds by Trump. And year in, year out, in a sort of routine way, Congress reauthorized that provision, Section 5, but the Supreme Court just, a few years ago said, enough is enough. We're just getting rid of this. Congress, you can repass it. And of course they had, but if you want to start anew, but we think the kind of, penalty box treatment of these states has gone on long enough, and it's just an end. Goodbye, Section 5. Huge. It left, however, Section 2. And Section 2 says that if you do certain election-related things, a big part of it is redistricting, in a way that dilutes the power of minorities. It violates the minorities can come to court and get that action enjoined. And that is now by far where the action is under the Voting Rights Act. And very importantly, it is clearly, and the court has acknowledged, an effects test. You don't have to show that the states have sort of nefariously been looking specifically or acting for purposes of invidious racial discrimination. In fact, the typical pattern in which this comes up now is, and we're seeing this all over the country, we have seen it, is Republicans want to redraw a map, and they expressly want to minimize the impact of African American voters, and while proclaiming it's not racism, it's just raw political power. And it just so happens, and this is the animating fact, that African American voters are disproportionately likely to vote for Democratic candidates. And so that's the kind of notion. Can typically Republicans go redistricting that dilutes the power of minority voters? So, for example, you could have a state, the case here comes from Louisiana, is quite like this, where let's say the African American voters are 40%, and this is just a hypothetical, but there are 10 districts. You sort of push all the African American voters into one of you draw a completely crazy line that puts all the African American voters in one district. So that district, the likely result is an African American candidate wins 99% of the vote, but that it adds up to one rather than anything commensurate with the population in the state. That sort of thing, because of its impact on race, just the mere effect, is a violation of Section 2. And that's where the big action is now. The Supreme Court has endorsed it in the wake of its gutting of Section 5 until now. There are at least 3 votes we know in the Supreme Court. You can guess who they are, but their initials are Gorsuch, Alito, and Thomas, who have made it clear that they think that Section 2 should not be able to be enforced by people, that people should not have standing to come to court, and people and groups, whatever. We know about standing now and how that works. And so under Section 2, it's always been the law that the people whose axe is gored, the actual voters, often kind of, consortiums, voting organizations, they come to court. They did this thing to us. Our voting power, including voter A, B, C, D, who are all in there, has been diluted, and we want a remedy. Supreme Court is suggesting, and they served it up basically for it's not as if the parties pressed them on this. It's a case that's already there from Louisiana, and they said, why don't you talk about this as well? So that's a chilling portent that there are potentially 5 people to do this holding. And the holding would be, yes, Section 2 says this can't be done. Yes, Section 2 says that a redistricting that dilutes the votes of African American voters can't be, if properly challenged, has to be rescinded. But people can't properly challenge it because Congress didn't intend, this is the argument, to permit it. It passed this law, but there are a lot of laws out there that you can't sue under. There's not a so-called private right of action. And so here goes the argument. The Congress didn't intend a private right of action, so Section 2 is sitting out there, but it doesn't permit individuals or groups who are actually getting their votes diluted to bring a lawsuit. Maybe the United States could, potentially a state, but who's going to do it, right? You're in a state that's roiled with this where the majority is controlling and doing it. There's no state official function to do it. The feds in this, environment never will. It would essentially completely gut the remaining viable part of the Voting Rights Act, that is to say, Section 2. And relatedly, there are, because it's a constitutional right, there have been a couple ways of trying to enforce it. One, in a direct lawsuit under the Voting Rights Act, Section 2, with the notion that Congress meant to provide it. And then there's another backstop, which is to sue under 1983, the general statute that says they've intentionally violated my constitutional rights. It doesn't have to show invidious racial discrimination, but they did something knowing that it was violating our rights. I'm suing under 1983, incorporating voting rights. So I just have to do it under 1983. And part and parcel of this view that Gorsuch, Alito, and Thomas, and who the hell knows, Kavanaugh, Barrett, Roberts might endorse is, you can't do it under 1983 either. So we have Section 5 sitting on the books requiring pre-clearance by states that Congress designates. And since the court just wiped that slate clean, how many states are in that requirement of pre-clearance? 0. Exactly 0. So Section 5 is a dead letter. And Section 2 now would become potentially very close to toothless. Deep, deep irony on, this is the week of the 60th anniversary of the Voting Rights Act. Democrats have tried again and again to build from there with the John Lewis Act for the great civil rights leader who died a couple years ago. All of it is just going nowhere under this Congress. But now the Supreme Court throws a stink bomb into the middle of the whole voting area by suggesting it may be prepared to basically cut off the remaining limb of voting rights enforcement. Keep your eye on it. Parties will brief it. It'll be argued, decided within a year. Very, very potentially foreboding development. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.